Coming to the next topic, which talks about family court, which is part of your polity section. Now, what happens? A 21-year-old woman who was married at the age of 12, she has secured an annulment of her marriage. That means her marriage has been cancelled by the family court. Clear? The court noted the adverse impact of child marriage on the present and future of children and emphasized the need for societal efforts to eliminate the practice of child marriage. Now, in this article, what we have to study? We have to study what are family courts. So basically, your family courts are established under Family Courts Act of 1984. The aim of establishing these family courts is to have speedy trials, speedy jurisdiction, your inexpensive trials, so that you don't have to hire a lot of lawyers, you don't need to go to far off places to access the courts. Then amicable settlement within family disputes, so that family dispute does not become enlarged. It remains a small dispute and it is solved by talking. It is set up by state government. There is no role of central government here. Family courts are entirely set up by state government. This is an important information for prelims perspective. It is done in consultation with the High Court. So state government in consultation with the High Court set up these family courts. What are the objective we have seen? To promote conciliation over litigation, so that the burden on courts is also reduced. At the same time, the process can be done speedy. It to reduce burden on regular courts, to ensure family harmony and welfare, so that see, if a lot of cost and litigation is involved, it leads to very bad situation where family breaks permanently. So that situation is also has to be avoided here. These family courts are mandatory in cities with population of more than 1 million or 10 lakh. So any city having more than population of 10 lakh, it is mandatory. But any city apart from it, if they want, family court can also be set up in other areas based upon the need. However, if the city is large enough, having more than 1 million population, then it is mandatory to set up. What are their jurisdiction? Largely marriage disputes like divorce, nullity, basically nullifying the marriage, then restitution of conjugal rights, rights to women, all these things, reproductive rights, all these things, although they are not very much talked about. Then maintenance of wife, children, parents by any person within the family. Then custody of children, it can also be seen by family courts. Your legitimacy of marriage or any child, whether that marriage has done is legitimate or not, whether the woman was married when she was a child below 18 years of age. Then property disputes between spouses is also seen by the family court. So all matter relating to family and marriage are resolved by family, marriage, child and parents. All these are resolved by these family courts. What else you need to remember is that there are special features of conciliation first approach. That means they try to mediate first, they try to resolve the dispute, then they take shape of a court. Then court decides, okay, we will decide, you get this, you get this. Otherwise, initially they try through mediation things can be solved. Then it is flexible and informal. That means they are not strictly bound by Code of Civil Procedure or Indian Evidence Act or Bharatiya Nyaya Sanhita. They are not bound by these acts. They work on the principle of natural justice. Principle of natural justice. Clear? So the proceedings are done in camera to have a proof of recording. So largely these proceedings are private behind closed doors to protect the dignity of different parties, because now the people from both the sides are from a family. So their family dignity has to be maintained. Lawyers are not mandatory. However, if the requirement of lawyer is there, then they can be allowed only with the court's permission. Otherwise, lawyers are not required. Lawyers are required in conventional court, which follow CRPC, Bharatiya Nyaya Sanhita and Evidence Act. But here they are not followed. So you have to remember this thing. Now their appeal, they have only one right to appeal, which lies in High Court. Now this is again very important. They have one right to appeal, that is only in High Court, which has to be filed within 30 days. After the lapse of 30 days, that means after 30 days, you cannot file appeal. So this you have to remember. Now what are the exam traps here, which you have to keep in mind for prelims? It is established under constitution, wrong. It is established by statute. So these are statutory courts or statutory bodies. They are set up by central only, again wrong. They are set up by states on the advice of high courts. Lawyers are mandatory, no. Lawyers are optional, generally they are not required, but if required, court can allow them. Open court proceedings are done, again they are wrong. The proceedings are closed door to maintain the dignity of family. What more you have to remember, their appeal does not lie to district court, their appeal lies to high court. Clear? Remember this thing. And they do not follow the Evidence Act and CRPC, all those things. They follow principle of natural justice. All these things you have to remember in family court.